Now let's talk about negotiation. So what is negotiation? So based on section 30 of the Negotiable Instruments Law, this is the transfer of the instrument from one person to another in such a way as to make the transferee the holder of the instrument. So here, class, the purpose why we have to negotiate an instrument is to make the transferee, the person to whom you transfer the instrument, to make that person the holder of the instrument. Because remember, if you are the holder of the instrument, you have the right over the instrument, you can collect, now you can recover based on the amount due written on the instrument. So, if the instrument is transferred to another, and that person does not become a holder but a mere transferee only, or just a mere assignee, then there is no negotiation. The transfer class, always remember that the transfer must make the transferee a holder for a negotiation to exist. To make one a holder, the negotiation must be in accordance with the rules, no? So if the intention is just to make the person an assignee or a mere transferee, then you don't have to negotiate. Meaning that instrument is not a negotiable instrument because it does not make the transferee the holder of that instrument. So always remember, in negotiation, what's the purpose? That is to make the holder of the instrument a holder, the transferee a holder, no? The transfer itself would make the transferee a holder. Not a mere transferee, not a mere assignee, but a holder. There are two kinds or modes of negotiation. We have the issue, and the second is endorsement. When we talk of issue, that means the first delivery of the instrument that is complete in form to a person who takes it as a holder. So a negotiable instrument's life does not begin until the maker or the drawer issues it to the first holder. So when we say issue, that pertains to the first delivery. Let's have an example. So in this example, M makes a note payable to the order of P for 50,000 pesos. Then P endorses it to A. So here we have a maker who is M and we have the payee who is P. And then M makes the note in favor or to the order of P for 50,000. So the payee is P. So we have here the first issue, no? The first delivery of the note from M to P. So that is an example of issuance, the first mode of negotiation, the first delivery of the negotiable instrument from the maker to the first holder, who is in this case P, the payee of the note. The second mode of negotiation is endorsement. That now pertains to the subsequent ones, no? The subsequent deliveries, the subsequent holders, or the subsequent transferees. Now, negotiation and endorsement are often used interchangeably. So, negotiation ordinarily involves endorsement. Now, negotiation makes it possible for the transferee to acquire a better right to a negotiable instrument that the transferor had. So whether the holder is a holder in due course, that now depends upon the factors other than the fact of negotiation. So always remember, when we talk of endorsement, we are not talking about the first delivery of the negotiable instrument. We are not talking about the first issuance, but we are talking about the subsequent negotiation of that negotiable instrument to the subsequent transferees or holders. Let's have an example. In this example, M makes a note payable to the order of P for 50,000 pesos. P endorses it to A. So the maker is M, the payee is P. However, the first holder, who is P, endorses the note to A. So here, there is what we call endorsement between P and A. And that is a subsequent transfer from P to A of the negotiable instrument. So A now is what we call the transferee. No? A acquires a right to the negotiable instrument, to the note here, to the promissory note coming from P, because P endorses the note to A. So that's an example of endorsement. That is not the first issuance, not the first delivery, but the subsequent endorsement or transfer or delivery coming from M to P, then P to A. A being the second holder of the note or the subsequent holder of the note by virtue of the endorsement made by P to A. Now remember this, okay? This is a reminder to all of you that negotiation of an instrument depends on whether that instrument to be negotiated is payable to order or payable to bearer. Because class, if it is payable to order, then the instrument is negotiated by endorsement completed by delivery. So endorsement plus delivery, partner jud ng duha, if and only if the instrument is payable to order. And I presume that you already know the difference between an instrument payable to order and an instrument payable to bearer. We have discussed that one in our previous meetings, no? So remember, if it is a payable to order, ay nakabutang na order sa instrument to the order of P or P or his order, no? That's endorsement plus delivery. What if the instrument is payable to bearer? Remember kato mga payable to bearer when it is expressly so payable to bearer, payable to a non-existing or a fictitious person, okay? When the only and the last endorsement is in blank. Hope you remember them, huh? So if it is payable to bearer, then no need for an endorsement, class. There's only one act required here, and that is delivery. Okay? So please remember this. If it's payable to order, endorsement plus delivery. That is the correct way of negotiating an instrument, the proper way of negotiating an instrument. Otherwise, if it is payable to order, then you only endorse it without any delivery at all, then there's no proper negotiation. So it would not make the transferee a holder. Now, if it is payable to bearer, only delivery, no need for you to endorse. Di na ka mag-endorse, magsulat pa to whom you're going to endorse the instrument. All you have to do is to deliver that to the person na gusto nimo maging holder of the instrument. So the correct endorsement will really make the transferee a holder. A holder is defined as the payee here, no? Or the endorsee, who is in possession of the instrument or the bearer thereof. So he becomes an endorsee class by endorsement to him, and he becomes in possession of the negotiable instrument by delivery. So kay gi-endorse man to sa iya, endorse na ang tawag. Plus, since it is delivered to him, so he's in possession of that instrument, he becomes the holder now of that instrument. That is for the payable to order, endorsement plus delivery. For payable to bearer, he also becomes a bearer, okay, meaning the holder of the instrument by mere delivery only. So, unsa ng endorsement? Kasi ang delivery, we all know, you just have to deliver it. Ihatag nimo sa tao, no? Ihatag nimo sa transferee with the intention to make the transferee a holder. But how about endorsement? What is endorsement? Endorsement class constitutes the writing or the signing by the endorser of his name in the instrument with the intention to transfer it to another, to make that person, that endorsee, what? A holder of the instrument. So, where do you usually make an endorsement? This is written usually on the back portion of the instrument. Just like this. Sa likod ng instrument, sulatan nimo, pay to be, signed A. So meaning i-endorse nimo ang instrument to B. Make sure that you're going to sign the instrument. Otherwise, no proper endorsement is being made. Also, class, usually nasa back portion of the instrument, but you can also endorse on the front portion, the front page, no? On the face of the instrument, you can also do that. So pwede sa likod, pwede sa face of the instrument or front page ang endorsement. Ingana ang noun sa endorsement, paid to be, then signed by the endorser. The endorser there is A. Also, the endorsement may be written on a separate sheet of paper. And if that is being done by the endorser, you call that separate sheet of paper as a allonge. Okay? Allonge. You have it in your textbook. A-L-L-O-N-G-E. Allonge. So, three ways, no, of endorsing: on front, at the back of the instrument, and the third one is on a separate sheet of paper. Let's go to the different kinds of endorsement. We have 5 of them. The basic, no? We have the special endorsement under Section 34 of the Negotiable Instruments Law, blank endorsement, Section 35, restrictive endorsement, Sections 36 to 37, qualified endorsement, Section 38, and we have conditional endorsement, Section 39. Let's discuss each of the kinds of endorsement. Kind of endorsement is this special endorsement. So this is the endorsement which specifies the name of the endorsee aside from the signature of the endorser. So the endorsement by the endorsee is necessary to negotiate this kind of instrument. So you have there the name of the endorser, A, and it specifies also the name of the endorsee, who is B. So that is special endorsement. When it specifies the name of the endorsee, aside from the name of the endorser, both are there, the endorsee and the endorser, then that is what we call special endorsement. Second endorsement is blank endorsement. I think familiar mo sa blank endorsement when we discussed an instrument payable to bearer, no? This endorsement does not specify the endorsee, and what appears is only the signature of the endorser. As you can see there, blanco ang name ng endorsee, but in the special endorsement, natay pay to be, remember? But there is none, blank lang siya as to the name of the endorsee. But what you can see there is only the signature, the name of the endorser, who is A. So, an endorsement or an instrument with a blank endorsement under this kind of endorsement may be negotiated by mere delivery. So when you say blank endorsement, since there's no mention of the name of the endorsee, this can be negotiated by mere delivery. What is important, class, dapat na ang pangalan ng and signature ng endorser, who is A. Kasi kung walang pangalan ni A dira, that cannot be under the blank endorsement na instrument. Why? You do not know kinsa ang nag-endorse. Okay lang, wata kabalo kang kinsa gi-endorse kasi blank endorsement. But please, if you're going to endorse, make sure that even if it is a blank endorsement, for it to be negotiated, okay, always make sure that the signature, the name of the endorser is there. Just like in that example. A, the signature of A, the name of A is there. Okay? So here, this may be negotiated by mere delivery if the blank endorsement is the only or the last endorsement. So this kind of endorsement transforms an originally ordered instrument to a bearer instrument. Remember when we discussed an instrument payable to bearer? Originally, it is an order instrument payable to the order of P. However, the only or the last endorsement is in blank, then that order instrument has been converted into a bearer instrument. And once it is converted to a bearer instrument, kasi blank endorsement man siya, then it can be negotiated by mere delivery. No need for endorsement. Unlike sa order instrument, diba? Endorsement plus delivery. But when we talk of bearer instrument, only delivery na lang. Why bearer naman siya, ma'am? Because from the original order instrument, it has been converted to a bearer instrument. Why? Because, ang iring nagakos? No, because the only or the last endorsement is in blank. So kapag blank endorsement class, automatic bearer instrument na siya. Okay? Bisag order instrument pa na siya, the fact na endorsed in blank, automatic converted na siya into a bearer instrument. And once that happens, it can be negotiated by mere delivery. Okay. However, if the holder wants to retain the character of the instrument as an order instrument, the holder is allowed by law to convert the blank endorsement into a special endorsement. How? Kung gusto jud nimo order instrument gihapon, dili siya mahimog blank bearer instrument. Gusto nimo siya mabalik sa original state niya of being an order instrument. All you have to do is insert the name of the payee or the holder or the transferee or the endorsee above the endorser's signature. So butangan na nimo kanang blanco dira, butangi og pay to B. And if you're going to insert that phrase, pay to B, then from order instrument to bearer instrument back to order instrument. And when it becomes an order instrument, unsa mahitabo? Ang negotiation, duha na. Endorsement plus delivery. Dili na pwede ang delivery lang. Okay? So that's it under blank endorsement. Restrictive endorsement under Section 36 of the Negotiable Instruments Law. Now, this kind of endorsement is any of the following, no? Number one, it prohibits the further negotiation of the instrument. Number two, it makes the endorsee the agent of the endorser. Number three, it makes the endorsee a mere trustee. So here, the holder is deprived to have title to the instrument because the instrument now ceases to be negotiable kasi restrictive siya. Now, the word restrictive implies that the holder acquires limited rights under the instrument. Thus, while he is a holder, he may not be allowed to negotiate the instrument any further. As when we have that first example, okay, to A only, signed B. So here, A can no longer negotiate the instrument to someone else. Kaya gibutang only. That only there makes it a restrictive endorsement. Kay A lang jud siya. So, the negotiable instrument there ceases to be negotiable. Kasi specified na ang payee and there is a restriction there that it is only to be paid to A. Okay? Only to A, not to someone else. Another kind of restrictive endorsement is one when the holder is deprived to have title to the instrument because now he is merely either an agent or a trustee. So, for example, number two, pay to A for collection, signed B. So, this makes A only an agent. Okay? His duty here is merely to collect and he is not the title holder. Again, in number two example, A is only authorized for collection purposes. A is not a holder here. Limited lang ang iyang right. And what is that? To collect. Dito ka magbayad kay A for collection. A is not a title holder. He has no other right than for collection purposes lang. Okay? Also, when the endorsement is written as pay to A in trust for B, signed B, here A, as the transferor endorsee, is merely a trustee. So it doesn't make A a holder. So A has no other right over the instrument but a mere trustee for B. So si B, gagunit lang siya para kay B. No, gagunit lang sa katong kwarta na ibayad sa iya ha for B. Ihatag lang gihapon to niya kay B. Okay? So pay to A in trust for B, signed B. Now, the restrictive endorsement does not deprive the endorsee of all the rights of a holder class. It only limits the rights kasi the restrictive endorsee also has the following rights. Kana si A dira, no? Restrictive endorsee na si A. Kasi ang endorser ay si B. So A has the right to receive payment. A has the right to bring an action over the instrument. A has the right to transfer his rights as an endorsee. Pwede niya i-transfer yung right as an endorsee to C, to another person, provided that it is not prohibited by the endorsement made by B. So, an endorsee as an agent or a trustee under the restrictive endorsement may endorse the instrument to another and negotiate the same. However, remember that the subsequent endorsee also becomes either an agent or a trustee. But the endorsee can no longer negotiate the same as when the endorsement is written as paid to A only, kana dira, or to A and no other person. So it really says to be a negotiable instrument. Okay? So kung i-endorse man ni A, i-transfer man ni A yung rights kay C, si C, mere trustee lang gihapon. Si C, mere, agent lang gihapon. But when we talk of the first example, to A only, A cannot and can never transfer his rights to C. Kasi taman lang dyan na kay A. But as to numbers 2 and 3 na examples, pwede niya ma-transfer iyang rights for collection kay C. Pwede niya ma-transfer iyang rights as a trustee kay C. Okay? So, that is under the restrictive endorsement. We have qualified endorsement. This makes the endorser a mere assigner of the instrument because the instrument here is made by adding the words without recourse or other similar words like sans recourse or no recourse or at endorsee's own risk. No? Just like in that example, pay to A without recourse, sign B. That example is under the qualified endorsement. If this is the kind of endorsement, then the endorser is not an endorser class. B here, being an endorser, is a mere assigner, not an endorser. So the endorsee here, si A, cannot hold B, the endorser, liable because an assigner cannot generally be held liable by an assignee. So, murag assignment lang ang nahitabo diri. There was really no negotiation, no endorsement. So, when we talk of a qualified endorsement, pag naa ang words na without recourse, sans recourse, no recourse, endorsee's own risk, kana na mga words or phrase, that makes the assigner, that makes the endorser here be as a mere assigner. And ang transferee as a mere assignee. And the assigner cannot be held liable by the assignee. So si B, dili siya manubag kay A. Kasi qualified man ang endorsement. Okay? Now, when the endorsement is qualified, the endorser is free from liability, as I've said, no? Katong si B kaganiha, being an assigner, free from liability. So in case that the endorsee cannot collect from the party primarily liable on the instrument. However, there is an exception. When the party sought to be held liable does not pay the holder or the endorsee because the instrument is, let's say, for example, forged, then the qualified endorser may be held liable under his warranties. So that's under Section 65, stating that every person negotiating by a qualified endorsement warrants that the instrument is genuine in all respects what it purports to be. In other words, liable na si endorser. Kasi general rule, under a qualified endorsement, the endorser is not liable to the endorsee in case the endorsee cannot collect from the person primarily liable on the instrument. However, there is an exception to that general rule. In case of forgery class, a qualified endorser can be held liable, no, by the endorsee. Like this example, number 2. Y issues a promissory note payable to X. X then endorsed it as follows. So sa likod, nagsulat siya. Subject to no recourse, paid to Z, signed X. So from Y to X, then from X to Z. Now, when Z went to collect from Y, katong person primarily held liable on the instrument, it turned out that the signature of Y was forged. So question, can Z collect from X? So that's the question. Can Z collect from X katong endorser, no? Si qualified endorser si X, si qualified endorsee si Z. So can Z collect from X? The answer is yes. That is under the exception to the general rule. Because X, as a qualified endorser, warrants that the note is genuine. Even if in truth and in fact, the signature of Y was forged. But under the law, that qualified endorser warrants that the signature of the maker here, Y, is genuine. So if that would be the case, then the qualified endorser will be held liable by the qualified endorsee, Z. So Z can collect from X. Last endorsement, kind of endorsement, we have conditional endorsement. So this endorsement imposes a condition before the payment is made. No? For example, pay to A if he passes the CPA board exam, signed B. So under this endorsement, A will not receive payment until he passes the CPA board exam. So this condition attaches to the instrument if negotiated by, let's say, A to D. Then D has to wait for the passing of A in the CPA board exam. However, class, the person who is to pay the instrument has the option to disregard the condition and pay the holder despite the condition and without regard as to whether the condition has been fulfilled or not. So, pwede ang mahitabo if the instrument has been negotiated by A to D, and then if D would like to collect na on the instrument, pwede dili na hulaton nga makapasa si A. Pwede bayaran na diretsyo si D. D can collect regardless as to whether that condition of A's passing the CPA board exam has been fulfilled or not. So, depende na sa person liable to pay. Pwede pod hulaton nga makapasa si A sa board exam. Pwede pod dili na. Kung gusto ni, let's say, maningil na si D kay B, no? Si B, if B would disregard the condition, then okay lang. B can automatically and can immediately pay D without waiting for A to pass the CPA board exam or without waiting for that condition to be fulfilled. So the endorsement class may be a combination of a special endorsement on the one hand and the restrictive and qualified and conditional endorsement on the other hand. So pwede siya matawag na special restrictive, pwede pod special qualified, pwede pod special conditional. So pwede nimo when you're going to endorse, no, if you are, let's say, the endorser, pwede nimo i-combine. It depends on you. Okay? So that's the conditional endorsement. And next meeting, we're going to discuss another topic. I think next meeting is your examination na, okay? So after your examination, your midterm examination, we're going to have another topic, no, under endorsement.